Good morning, this is your Kelso Report for Monday, May 7th, and I'm your host, Clark Kelso. We have cases today dealing with the civil rights of foster children, limitation of action in habeas corpus, and a government law civil service case involving school districts in San Francisco. We'll begin with the Ninth Circuit on the civil rights of foster care children. In Henry A. versus Wilden, the Ninth Circuit approved most of the causes of action pled in the plaintiff's class action, brought under Section 1983, against Nevada state and county officials in favor of foster children, subject to the jurisdiction of Clark County, Nevada, when the complaint alleges violations of the foster children's 14th Amendment rights and rights under the Federal Adoption Assistance and Child Welfare Act, the Child Abuse and Treatment Act, and the Individuals with Disabilities Education Act. The complaint sought both injunctive relief and damages. The district court had dismissed most of the claims. The constitutional claim was dismissed on grounds of qualified immunity, and the statutory claims dismissed because the court did not find the statutes created a distinct federal right enforceable by the courts. The Ninth Circuit reversed on all claims. As for the 14th Amendment, although it generally does not impose a duty on the state to protect individuals from third parties, that general rule has exceptions when there exists a special relationship between the state and a particular class of persons, and when the state's own actions place someone in danger by acting with deliberate indifference to a known and obvious danger. Both of these exceptions applied in the context of the allegations in the complaint involving foster placements made by Nevada County officials. According to the complaint, allegations of physical abuse and neglect and failure to provide proper medical treatment to foster children were routinely ignored by local officials to the detriment of the foster children. The qualified immunity argument was really unsuccessful for obvious reasons. First, it doesn't apply to injunctive relief at all, and even as to the damages claim against the federal officials, fact questions existed as to whether they were violating known constitutional rights. The federal statutory claims involve the failure of state and local officials to implement the case plan and records provisions of the Child Welfare Act, the Guardian ad litem provisions of the Child Abuse and Treatment Act, and the Early Intervention Services provisions of the Individuals with Disabilities Education Act. Now, with respect to each of these claims, the Ninth Circuit joined a number of other circuits recognizing that these acts create individual rights that are enforceable in the courts by a private right of action, even though the acts are typical spending clause legislation that create federal requirements only if the state accepts federal money under each act. Nevada, like pretty much everybody else, accepts the federal money. Next, we have a couple of habeas decisions from the Ninth Circuit. The first involves limitation of actions in Neds versus Calderon. The habeas petitioner's federal petition, which was filed way back in 2001, would have been timely pursuant to applicable Ninth Circuit precedent at the time, on which the petitioner was entitled to rely in deciding when to file his federal petition. However, that Ninth Circuit precedent was overruled implicitly by the United States Supreme Court in 2002. That, of course, was after the petitioner had filed his federal petition. In these circumstances, the petitioner is entitled to the benefits of equitable tolling for the entire time he pursued his state habeas petitions, because that was the import of the state habeas of the Ninth Circuit's law on which the petitioner justifiably relied in deciding when to file his federal petition. With the benefit of equitable tolling, the petition was timely filed within the one-year habeas limitations period established by the Anti-Terrorism and Effective Death Penalty Act. Next, in Crosby versus Schwartz, the Ninth Circuit rejected the petitioner's habeas petition, finding that none of the three grounds for relief in the petition were meritorious. The petitioner challenged the California Court of Appeals' conclusion that his waiver of his Sixth Amendment right to a jury trial was valid, that the Superior Court did not err in rejecting his subsequent attempt to withdraw his waiver, and that his 26 to life sentence under the Three Strikes Law did not constitute cruel and unusual punishment. Applying the appropriate standard of review, the Ninth Circuit concluded that these rulings by the California Court of Appeal were neither contrary to nor involved an unreasonable application of clearly established federal law. Now we turn to an interesting decision involving schools and civil service. It applies, however, really only in the city and county of San Francisco. This is a San Francisco-only dispute. The First District held in San Francisco Unified School District versus City and County of San Francisco that the state statute, which established a unified civil service system encompassing both city and school district employees in San Francisco, does not unconstitutionally deprive the school district of management and control over the schools. Back in the 1940s, every other school district was given the ability to establish its own separate civil service merit system. But in San Francisco, the legislature decided to maintain a unified system that included both the school district and the city. Now this means, for example, when the city implements layoffs, seniority bumping rights can result in an impact on school district employees. The school district's lawsuit, however, failed on the issue of whether transfer of control over the civil service system constituted an unconstitutional transfer over management and control of the schools themselves. The First District held that the civil service system is not such an integral part of the schools that vesting control over civil service in the city was tantamount to depriving the school district management and control over the schools. Of particular importance to the court, the school district retained management control over all of its employees, retaining the ability to set the duties of employees to discipline and dismiss for cause, and even to terminate an incoming bumper for any reason during that employee's probationary period. In other words, the fact simply did not establish that the school district lost management control over its employees by virtue of being part of the city's civil service system. And that's it for today's Kelso Report. Have a great day in the law.